Welcome back to LexTalks, where we simplify those tricky legal topics, make them actually useful. So today, we're going to dive deep into something that's super relevant for you guys, all you Indian law students out there, enforcement of foreign awards, specifically looking at procedure and essentials under the New York Convention. You've probably all got, notes, articles, maybe even some case summaries tucked away. We're going to connect the dots today, get those aha moments, really make this topic click.
It's like we're solving a puzzle, figuring out how those decisions made in courts outside India, how those can actually be enforced right here in your backyard, basically.
Okay, so let's back up a sec before we get lost in the maze here. What exactly are we talking about when we say foreign awards? It sounds pretty official, right?
Oh, it definitely is. Imagine this. Two companies, one from India and one, let's say, from the UK. They're having this contract dispute. So they go through arbitration, right? And the arbitrators, they make their decision in London. That decision, that binding resolution, that's your foreign award. It's like a judgment, but it's from a court outside India.
So it's not like this London decision automatically applies in India, right?
Yeah.
There's got to be a process, some way to make it official here.
You hit the nail on the head. That's where the New York Convention steps in. It's like a global agreement, a legal handshake, you could say. It's between countries saying, we'll respect each other's decisions, but here are the rules of the game. And India, being a signatory, well, we've agreed to play by those rules.
Okay, that makes sense. But why do we even need this convention in the first place? Why not just treat any foreign judgment like it came from, an Indian court?
Well, think about it. Every country has its own legal system, its own ways of doing things, right? The New York Convention, it's like a common framework, a sort of universal translator for these foreign decisions. It makes sure they're treated fairly and consistently across borders, makes things smoother for everyone.
So what's the magic formula? How does this New York Convention actually work in practice? I'm curious.
Okay, so picture this, a two-part test. First, we have to figure out if the award is even enforceable in India, kind of like a quality check. Were the parties involved actually capable of making this agreement? Was the arbitration process fair and impartial? Was the subject matter even something that can be arbitrated in the first place?
Okay, so we're making sure the award itself is legit. But even if it passes this test, it's not like India just throws open the doors and says, come on in, right?
Exactly. That's where the second part comes into play, actually enforcing the award within India's legal system. It's like taking that foreign decision and giving it the same power as a decree from an Indian court. Now, it can be executed here.
Okay, I see. This two-part system is fascinating. I'm starting to see why this convention is so important, especially now when businesses are operating across borders all the time.
Precisely. And this two-part system, it's pretty clever, actually. It makes sure there's a balance between upholding international agreements and also safeguarding India's own interests. It's like a legal balancing act.
Okay, so let's say a foreign award has made it through the first test. It's deemed enforceable. Who gets to make it official here in India? Is it any court, or is there a specific process?
It's not just any court. Only the high courts in India have the power to handle these enforcement applications. Imagine walking into those grand halls, lawyers presenting their arguments, and the judge ultimately deciding whether or not to give that foreign award the force of law right here in India. Pretty dramatic, right?
Sounds intense. But even with these safeguards, India can still say no to enforcing a foreign award, right? I've heard about this public policy exception.
You're right. That exception definitely exists. It's like a safety valve for India, allowing us to refuse enforcement if the award goes against our fundamental laws or public interest. It's a big deal.
That makes sense. But public policy sounds pretty broad. How does India decide what actually falls under that umbrella?
It's a complex area. It's evolved over time through various court decisions. It's not just about disagreeing with the outcome of the arbitration. It has to be something that really clashes fundamentally with India's core values or legal principles.
So it's like a last resort, not just a way to get out of decisions that are inconvenient. But I imagine it's a pretty controversial area, right? There must be lots of debate about when it's appropriate to use this exception.
You're spot on. It's a delicate balancing act, and there's always this tension between upholding international agreements and also safeguarding national interests. It's a tough one.
I can see why this is such a crucial topic for law students in India. If you're going to be dealing with international contracts or disputes, understanding this whole system is essential. But before we get ahead of ourselves, let's focus on one key element, the New York Convention.
Good idea. Understanding its nuts and bolts is key to really grasping how all of this works in practice.
All right, so what are the absolute essentials of this New York Convention? What are its core principles, and how does it play out in real-life situations?
Well, at its heart, the convention is all about making international arbitration awards enforceable, across borders. It's built on this idea of reciprocity. Countries agree to enforce each other's awards, creating a level playing field for businesses and investors operating globally.
So it's like a legal support system for international commerce, but it's not a blank check, right? You talked about the public policy exception. Are there other situations where a country might refuse to enforce an award under the convention?
Absolutely. The convention actually lays out specific grounds for refusal. For example, if one of the parties involved wasn't capable of entering into the agreement, like if they were a minor or lacked mental capacity, enforcement might be refused.
That makes sense. It's about being fair and protecting vulnerable parties.
Exactly. And it's not just about the parties themselves. The convention also looks at the process, the arbitration process. Was the agreement to arbitrate valid? Was the composition of the arbitral tribunal impartial? Were both sides given a fair chance to present their case? All these factors can come into play.
So it's not just about the outcome, but also about the integrity of the process itself.
Precisely. The New York Convention sets a high bar. It's for both the substance of the award and the procedure followed in reaching it. It's designed to, well, weed out any awards that were obtained unfairly or where fundamental flaws in the process occurred.
It's starting to feel like a legal detective show.
Right.
We've got the convention as our guide, and we're carefully examining all the evidence to see if the award meets all the requirements.
You got it. And remember, the New York Convention doesn't exist in a vacuum. It interacts with India's own domestic laws, court decisions, legal interpretations. It creates this fascinating and ever-evolving area of law.
Okay, we've laid the groundwork. We know what foreign awards are, why this New York Convention is so important, and the general process for enforcement. But I'm ready for some real-world examples, those landmark cases that really bring this topic to life. I'm thinking, cases like Vodafone and Glencore. Those seem pretty monumental.
You're right, they are. And they perfectly illustrate the complexities, the nuances of enforcing these foreign awards in India, especially under the New York Convention. Get ready for some legal storytelling. Things are about to get really interesting.
Before we jump into those captivating cases, I think it would be helpful to take a closer look at that public policy exception. It keeps popping up. It seems to be this recurring theme in the whole saga of foreign award enforcement.
You're absolutely right. It's a crucial piece of the puzzle, and understanding how it's been interpreted, how it's been applied in India, that's essential for anyone dealing with this area of law.
So let's unpack the public policy exception a bit further. What are some of the key considerations, the things courts are thinking about when deciding whether or not to actually invoke it?
Well, remember, the public policy exception, it's like a safety valve, right? Allowing India to refuse enforcement if the award clashes with our core legal principles, our fundamental values. It's not just about disagreeing with the outcome. It has to be something that strikes at the very heart of India's legal system or societal values.
So it's about protecting India's sovereignty, making sure foreign decisions don't undermine our fundamental legal framework.
Exactly. And this protection can extend to various areas. For example, if a foreign award is seen as violating India's constitution, its basic principles of natural justice, or its core concepts of morality, the public policy exception might be invoked in those cases.
It's like saying we're open to international arbitration, but we won't compromise on our fundamental legal and societal values.
That's right. And the courts have to carefully balance these competing interests, upholding those international agreements while also safeguarding India's own sovereignty. It's a tough job.
Okay, that makes sense. But I'm guessing this balancing act isn't always easy. There must be lots of gray areas, lots of debate. What actually constitutes a genuine public policy violation?
You're absolutely right. It's a complex area, lots of nuances, and there's no clear-cut formula. Courts have to look at each case on its own merits, considering the specific facts, the legal arguments, and the potential impact of enforcing the award. It's case by case.
So it's not about applying a rigid rule, but about making a judgment call based on the unique circumstances of each case.
Exactly. And this judgment call can be influenced by all sorts of things, evolving societal values, changing economic conditions, even political considerations. It's a dynamic field.
It sounds like navigating this public policy exception requires a deep understanding of India's legal system its social fabric, even its political landscape.
You're right. It's not just about knowing the black letter law. It's about understanding the bigger context in which this exception operates. It's bigger than just the words on the page.
I can already see how this public policy exception could become a battleground in these foreign award enforcement cases. Lawyers would need to be really strategic, really smart in how they frame their arguments, both for and against invoking this exception.
Absolutely. It's high stakes for sure. And the outcome can have major implications, not just for the parties involved, but for the future of foreign award enforcement in India as a whole.
Okay, we've delved into the public policy exception, but let's not forget about the other grounds for refusal that are outlined in the New York Convention. Can you give us a quick rundown, some of the key ones?
Sure. Remember, the convention sets a high standard. It's for both the substance of the award and the process followed, in reaching it. So if there were some fundamental flaws in the arbitration process, a country might refuse to enforce the award. Makes sense, right?
Like, what kind of flaws are we talking about specifically? Give us some examples.
Well, one common ground for refusal is if the parties involved, if they weren't properly notified of the proceedings, the arbitration proceedings, or if they weren't given a fair chance to present their case. That's a big one.
Yeah, that makes sense. It's about ensuring basic fairness, due process, that sort of thing.
Exactly. And another ground for refusal is if the subject matter of the dispute, if it wasn't something that could actually be arbitrated under Indian law. For example, certain family matters or criminal offenses, those might not be arbitrable. So an award dealing with those issues, well, it wouldn't be enforceable in India.
So there are limits to what arbitration can decide, and the New York Convention respects those limits. It's not a free-for-all.
Right. The convention acknowledges that national laws can vary. It doesn't try to override those laws.
It's like saying, we'll enforce your award, but only if it's within the boundaries of what our legal system actually allows.
Exactly. And another ground for refusal is if the composition of the arbitral tribunal, if it was biased or if there were serious doubts about its impartiality. The New York Convention really emphasizes fairness and neutrality in the whole arbitration process, so any hint of bias could lead to the award being set aside. That's a big one.
So it's not just about the outcome, but also about the integrity of the people making the decision. They need to be above board.
Precisely. The arbitrators, they must be seen as fair and impartial. Any doubts about their integrity could undermine the legitimacy of the entire process. It's all about trust.
These grounds for refusal, along with public policy exception, they really highlight the careful balancing act that the New York Convention is trying to achieve. It's about creating a system that's fair, efficient, and also respects the sovereignty of individual nations. It's a tall order.
You've summed it up perfectly. The convention, it aims to create a level playing field for international arbitration while also recognizing that each country has its own unique legal and societal context. It's about finding that balance.
Okay, we've got a good grasp of the New York Convention's framework, those grounds for refusal, the whole public policy exception. Now I'm itching to hear about those landmark cases, Vodafone, Glencore, and Balco. I'm ready for some legal drama.
You got it. Get ready to step into the courtroom as we unpack these fascinating cases and see how those principles we've discussed, how they play out in real life.
Before we dive into those captivating cases, I want to connect this back to our listeners. We've been throwing around terms like enforcement, arbitration, New York Convention.
Yeah.
But why should you, as Indian law students, why should you care about all of this? It seems pretty abstract.
That's a great point. It's easy to get lost in the legal jargon, but let's bring it down to earth. Understanding these concepts, it's crucial for your future legal careers, especially if you're thinking about international law, commercial disputes, even corporate law.
So it's not just theoretical knowledge, it has practical implications for you guys out there in the real world.
Absolutely. India is a major player on the global stage, and cross-border transactions, they're becoming more and more common. This means more contracts, more investments, and, well, inevitably, more disputes. It's just the nature of the game.
And if you're going to be advising clients or representing them in court, you need to know how to navigate these disputes, especially when they involve foreign parties.
Exactly. Imagine you're a lawyer working for an Indian company. They've just won a major arbitration award. It's against a foreign company. You need to know how to enforce that award right here in India to actually get your client the compensation they deserve.
Or imagine you're representing a foreign investor, and they're facing a dispute with the Indian government. Understanding the New York Convention, the public policy exception, that could be crucial for protecting your client's interests.
These cases, they're not just abstract legal principles, they have real-world consequences for businesses, for investors, even individuals. It's serious stuff.
So this knowledge isn't just about passing exams. It's about being an effective, a successful lawyer in today's globalized world.
Exactly. And that's why we're taking this deep dive to equip you with the knowledge, the insights you need to navigate this complex and fascinating area of law.
Okay, with that in mind, let's finally jump into those landmark cases. I'm ready to hear the stories behind Vodafone, Glencore, and Balco, see how they've shaped the landscape of foreign award enforcement in India.
Let's start with Vodafone. This case, it grabbed headlines, sparked debates, and ultimately clarified some crucial aspects of how India approaches the enforcement of foreign awards, especially, in the context of investment treaty arbitration.
Okay, set the scene for us. What was Vodafone all about? What were the key legal battles that unfolded?
Imagine this. A multi-billion-dollar tax dispute between Vodafone, a British telecom giant, and the Indian government. It all started back in 2007. Vodafone acquired a controlling stake in an Indian telecom company, and they did it through this complex deal structured via a Cayman Islands holding company.
So, classic case of international corporate maneuvering, huh?
Exactly. And that's where things get interesting. The Indian government argued that this offshore transaction, it was designed to avoid paying taxes in India. So they slapped Vodafone with this massive tax bill.
Whoa, talk about high stakes.
Right. Well, Vodafone disputed the tax demand and invoked the arbitration clause in the Bilateral Investment Treaty, the BIT, between India and the Netherlands. They argued that India's actions violated the treaty's provisions on fair and equitable treatment. They said it wasn't fair.
So they took the fight to an international tribunal. They went outside the Indian court system.
They did. But India wasn't backing down. They went to the Delhi High Court, trying to block Vodafone from even pursuing this arbitration.
Wow, a preemptive strike. What was their argument? Why did they want to block it?
India claimed that the dispute it wasn't commercial in nature, and therefore it fell outside the scope of the New York Convention. You see, India had made a reservation to the convention, applying it only to commercial disputes. So they're essentially saying this investment treaty arbitration, it didn't count.
So they were trying to draw a line in the sand saying, this type of dispute is off limits.
Exactly. It was a bold move, had huge implications for how India would be perceived by, the international investment community. It was a big gamble.
It sounds like a pivotal moment. So what did the Delhi High Court have to say about all of this? Which way did they go?
The Delhi High Court ultimately sided with Vodafone. They really analyzed the nature of the dispute, the purpose of the BIT, and they concluded that even though it arose from an investment treaty, the heart of the matter was still a commercial transaction. It was a share acquisition, plain and simple.
So they looked beyond the labels and focused on the substance of the deal, what it was really about.
Precisely. And they emphasized that the BIT, it was designed to protect foreign investments, which are inherently commercial in nature. They weren't going to limit commercial to just narrow traditional contracts. They recognize that in today's globalized world, commercial disputes can take all sorts of forms.
And this is where the New York Convention comes into play, right? How did the court interpret its application in this specific context?
The court noted that the convention, it doesn't explicitly define commercial, which gives states some flexibility in interpretation. However, they stress that this flexibility, it shouldn't be used to undermine the convention's core objectives, which is, facilitating the enforcement of arbitral awards.
So it's a balancing act, acknowledging national sovereignty while also upholding those international commitments.
Absolutely. The Delhi High Court's decision in Vodafone, it sent a strong message. India, despite its reservation, wouldn't shy away from enforcing awards, even in these investor-state disputes. As long as there was a clear commercial element involved, they were willing to play ball.
It's like saying, we're open to foreign investment, and we'll honor our commitments under international treaties. But we'll also carefully scrutinize the nature of the disputes, make sure everything is above board.
That's a great way to put it. The Vodafone case, it reassured the international business community, showed them that India was willing to play by the rules, but also that India would assert its right to interpret those rules within its own legal context.
It's like a legal dance, finding that balance between international principles and national interests. But the Vodafone case wasn't the end of the story, right? There's also the Glencore case, and it sounds like that adds another layer of complexity to this whole saga.
You're absolutely right. Glencore built on the foundation that Vodafone laid, but it tackled a different aspect of foreign award enforcement, the issue of territorial jurisdiction. Buckle up. Things are about to get even more intriguing.
Okay, I'm ready. Give me the plot of this Glencore legal thriller. How did it all twist and turn through India's legal system?
Okay, so Glencore, it involved another clash, this time between an international investor, a Swiss mining giant called Glencore, and the Indian government. The dispute was over a share sale. It was in Hindustan Zinc, a company where the Indian government had a significant stake. Glencore alleged that the Indian government breached the terms of their share purchase agreement, led to some big losses, and they took the matter to arbitration. This time it was under the rules of the London Court of International Arbitration, the LCIA.
So another high-stakes business deal gone wrong, huh?
Exactly. And just like in Vodafone, the international investor, they won a big award. But here's where the twist comes in. When Glencore tried to enforce this LCIA award in India, they hit a snag, a new hurdle.
What was it this time? What kind of hurdle?
The Indian government argued that the Delhi High Court, well, they didn't have jurisdiction to enforce the award. They claimed that their relevant assets of Hindustan Zinc, they were located in Rajasthan, not in Delhi. So they said the case should be filed there, not in Delhi.
So a jurisdictional tug of war. This is getting complicated.
It is. This whole question of territorial jurisdiction, it had been a bit of a gray area in Indian law. The Glencore case, it brought this issue to the forefront, forced the courts to provide some much-needed clarity. It was a big moment.
Okay, so what happened? Did Glencore have to pack their bags and head over to Rajasthan to file their case?
Nope, not this time. The Delhi High Court made a significant ruling. They clarified that a foreign award, it can be enforced in any court in India where the assets of the judgment debtor are located. They really emphasized that a foreign award, once it's declared enforceable, it becomes a deemed decree, and it can be executed just like any other decree of an Indian court. No special treatment.
So location is key, but this deemed decree concept, what does that really mean? Why is it so important in this whole context?
Think of it as a legal upgrade, a power-up. Once a foreign award is declared enforceable by an Indian court, it transforms. It goes from a foreign decision to a domestic order, giving it the same power and enforceability as a decree issued by an Indian court. It's like a legal chameleon.
Ah, so it gets assimilated, absorbed into the Indian legal system.
Yeah.
That makes sense. It becomes one of us.
Exactly. And this transformation is crucial because it allows the award holder, the winner, to leverage all of India's domestic enforcement mechanisms to recover what they're owed. It doesn't matter where the original cause of action arose, now it's an Indian matter.
So it's about being practical, making sure that justice is actually served and that awards are actually enforceable, not just theoretical victories on a piece of paper.
Precisely. And the Glencore case, it solidifies this principle, you know. It emphasizes that the location of the assets, that's key to choosing the right court for enforcement. It gives the award holders more flexibility, more options.
It's like saying, you've got your award, now go find the treasure. Go where the money is.
I like that analogy. It highlights the practical side of enforcement. It's not just about winning an arbitration. It's about being able to actually collect what you're owed. It's about getting your hands on the prize.
Okay, so we've got Vodafone clarifying how India approaches that commercial nature of disputes. And Glencore highlighting the importance of territorial jurisdiction and this deemed decree concept. I'm sensing a theme here. Both cases seem to be pushing India towards a more, well, pro-enforcement stance. Wouldn't you say so?
You're absolutely right. Both Vodafone and Glencore, they represent significant steps. They're moving India towards establishing itself as what we call an arbitration-friendly jurisdiction. They send a message to international investors that India takes its commitment seriously and provides a predictable legal framework for resolving disputes. They're saying, come invest here, we'll treat you fairly.
It's like building a reputation, saying India is a safe and reliable place to do business. We'll uphold our end of the bargain.
Exactly. And that reputation, it's crucial for attracting foreign investment, promoting economic growth. It all ties together.
But even with these pro-enforcement judgments, there's still one piece of the puzzle that we haven't fully explored, the public policy exception. I'm curious, how has this exception actually played out in Indian courts? What are some of the controversies, some of the challenges surrounding its application? It seems pretty tricky.
That's a great question, and it leads us to our third landmark case, Balco. This case takes us deep, into the murky waters of the public policy exception. We have to confront those fundamental questions. What happens when a foreign award, it clashes with a country's core values, with its interests? Get ready for some legal fireworks.
I'm intrigued. Give us the background. What was Balco all about, and how did this public policy exception become, the central issue.
Okay, picture this. It's 2001. India's in the middle of this big economic liberalization push. The government decides to divest its majority stake in Balco, a state-owned aluminum producer. Sterlite Industries, a subsidiary of Vedanta Resources, they win the bid. So a private company takes over a public sector company, big change.
Privatization. I can already sense the potential for controversy. Lots of strong opinions about that.
You're right. The move was met with resistance from, well, everyone. Trade unions, political parties, all sorts of groups concerned about job losses and the impact on the domestic aluminum industry. People were worried.
So a classic case of clashing interests, different perspectives.
Exactly. A few years after the privatization, Sterlite enters into a contract with the Indian government. It's for the supply of bauxite, the raw material used to make aluminum, but then the government, they terminate the contract. They cite Sterlite's alleged failure to meet certain obligations. Things went sour.
So the deal went bad. What happened next? What did Sterlite do?
Sterlite, feeling wrong, they invoked the arbitration clause in the India-Netherlands BIT, just like Vodafone did. They argued that the termination of the contract, it was politically motivated, that it violated the BIT's provisions on fair and equitable treatment and expropriation. They said it wasn't right.
So back to international arbitration. They're going outside the Indian court system again.
Yes. But this time, the public policy exception takes center stage. When Sterlite went to enforce the award in India, the government argued that upholding it would be contrary to India's public policy. They cited concerns about the domestic aluminum industry, the implications for the government's privatization policies. They were pulling out all the stops.
Sounds like they were pulling out the big guns, using the public policy exception as a shield to protect their interests.
Exactly. It became a battleground, with Sterlite arguing for the sanctity of the Arbitral Award and the Indian government invoking the public policy exception to protect what they saw as vital national interests. The case landed in the Delhi High Court, setting the stage for a high-stakes legal showdown. It was a big one.
Okay, we've got the scene set, the stage is set. Now I'm on the edge of my seat. What did the Delhi High Court decide? Who won this clash of the titans?
Well, get ready for a plot twist. The Delhi High Court, in a split decision, ultimately upheld the Arbitral Award, rejecting India's public policy defense. However, it wasn't a straightforward victory for Sterlite. There were some complications.
A split decision, huh? That suggests some serious internal debate among the judges. They didn't all agree.
You're right. The judges who formed the majority, they recognized the seriousness of the public policy argument. They understood the government's concerns about the impact on the domestic aluminum industry, but they stressed that the exception, it should be interpreted narrowly, applied only in really exceptional circumstances, not just any time.
So it's not a free pass to disregard foreign awards just because they're inconvenient or politically sensitive. There has to be more to it than that.
Exactly. They emphasized that the exception shouldn't be used to undermine the fundamental tenets of international arbitration or to, shield a state from its treaty obligations. There has to be a real reason.
It's like saying, yes, we have this safety valve, but we're not going to use it lightly. We'll respect the sanctity of the arbitral process unless there's a truly compelling reason to do otherwise.
That's a great way to put it. In the Balco case, they concluded that India hadn't met that high threshold. They pointed out that Sterlite had been given a fair chance to present its case. The arbitral tribunal considered all the arguments, and there wasn't any blatant violation of fundamental principles that would justify setting aside the award. They did their due diligence.
So it's about upholding the integrity of the process, respecting the finality of those arbitral decisions, unless there's a clear and compelling reason to intervene.
Precisely. But here's where the split decision gets really interesting. One judge dissented. They argued that the government's concerns about the domestic aluminum industry, well, they were serious enough to warrant invoking the public policy exception. It wasn't a unanimous decision.
A dissenting opinion always adds another layer of complexity. What was the reasoning behind the dissent? Why did that judge disagree?
The dissenting judge felt that the potential consequences, the economic and social consequences of enforcing the award, they outweighed the importance of upholding the tribunal's decision. They were thinking about the bigger picture, the impact on India. It's a classic example of the difficult balancing act that courts face, when they're dealing with the public policy exception.
It's like trying to weigh apples and oranges.
Yeah.
Economic interests versus the sanctity of international agreements. How do you even begin to compare those?
That's the million-dollar question. And the Balco case demonstrates that there's no easy answer. it highlights the inherent subjectivity and the need for careful judgment calls when dealing with the public policy exception. It's not a simple rule.
It's a reminder that law isn't always black and white. There are often shades of gray, and judges have to navigate these complexities to arrive at a just and equitable decision. It's a tough job.
Absolutely. And the Balco case, along with Vodafone and Glencore, they provide valuable insights into how India is grappling with these challenges, how India is shaping its approach to foreign award enforcement, and finding its place in the global landscape of international arbitration.
Okay, we've explored the depths of these three landmark cases, Vodafone, Glencore, and Balco. Each one's added a piece to the puzzle. We've got a clearer picture of how India approaches the enforcement of these foreign awards. But our journey isn't over yet. In part 2, we'll delve even.
Welcome back to LexTalks, where we try to break down the legal world one deep dive at a time.
And today, we're picking up right where we left off, still exploring this whole world of enforcement of foreign awards, focusing on procedure and essentials under the New York Convention. Remember in part 1, we kind of laid the groundwork, defined what foreign awards are, talked about the New York Convention, and that two-part test for enforcement here in India.
Right. And we touched on the public policy exception, that safety valve that allows India to refuse enforcement if an award goes against our fundamental legal principles or core values. It's a tricky one.
Exactly. And we talked about those three landmark cases, Vodafone, Glencore, and Balco. They've really shaped how India deals with this whole complex area of law. But now it's time to roll up our sleeves and really dissect these cases, get into the nitty-gritty. I'm ready to understand those legal strategies, the judicial reasoning, and the lasting impact they've had on India's arbitration landscape.
You got it. Let's start with Vodafone. This case, it was a game changer, really. It clarified how India looks at the commercial nature of disputes, especially when we're talking about, investment treaty arbitration.
Okay, let's rewind a bit, back to the specifics. We talked about that multi-billion-dollar tax dispute, the arbitration clause, and the India-Netherlands BIT, and India's attempt to block the whole arbitration thing altogether. But what were those key legal arguments? The ones Vodafone used to convince the Delhi High Court to let the arbitration go forward.
Vodafone, they had a brilliant strategy. They really honed in on the substance of the dispute, arguing that at its core, it was a commercial transaction, acquiring shares in an Indian telecom company. They kept emphasizing that the BIT, well, it was designed to protect foreign investments, which, are inherently commercial. That's the nature of investment.
So they're basically saying, look, beyond the labels, this is a business deal, plain and simple.
Exactly. And they highlighted the wording of the arbitration clause in the BIT. It was pretty broad. It covered any dispute that arose out of or related to the investment. That expansive language gave them leverage to argue that the tax dispute, even though it involved the government, well, it fell under that umbrella of investment protection.
So they were saying, we agreed to resolve any investment-related issues through arbitration. And this tax thing, well, it's part of that agreement.
Right, and they were smart about navigating that ambiguity around the term commercial in the New York Convention. Remember, the convention doesn't give a hard and fast definition, so there's room for interpretation. Vodafone used that flexibility to argue that India's interpretation shouldn't undermine the convention's main goal, which is, to make sure arbitral awards are actually enforced.
So it's a balancing act, respecting India's right to interpret the convention, but also upholding the whole idea of international arbitration.
You got it. And the Delhi High Court, in their decision, they acknowledged that balance. They said states have some leeway, but they shouldn't use that flexibility as a way to dodge their obligations under the convention.
So it's like a warning, saying, we're keeping an eye on things. We won't let you undermine the spirit of this whole international arbitration thing.
Exactly. The Vodafone case set a precedent, It limited the scope of India's reservation, and it sent a clear message, especially to those involved in investment treaty arbitration, that as long as there's a clear commercial element, India will play by the rules.
It's like drawing a line, saying, India is open for business, we'll honor our commitments, but we'll also scrutinize these disputes carefully. Everything needs to be above board.
I like that. The Vodafone case, it really reassured the international business community that India is a reliable place to do business.
Okay, so Vodafone addressed that whole commercial aspect of disputes. But Glencore, that brought up a different issue, right? Territorial jurisdiction. Can you remind us what happened in that case, how it impacted how India enforces these foreign awards?
Absolutely. Glencore, you'll remember, it was all about the share sale in Hindustan Zinc. Glencore won their arbitration case in London, but then they ran into a roadblock trying to enforce it here in India.
Right, the Indian government tried to use the location argument. Said the Delhi High Court didn't have jurisdiction because the assets were actually located in Rajasthan.
Exactly. And this jurisdictional challenge, it wasn't just a tactic. It actually exposed a genuine gray area in Indian law. There wasn't clear guidance on which court was the right one to enforce foreign awards, especially when assets were spread out across different states.
So the Glencore case forced the courts to clear up this confusion, right? To provide some guidance.
They did, and the Delhi High Court's decision, it was huge. They said a foreign award, it can be enforced in any court in India as long as the judgment debtor's assets are located there. They really brought the focus to the practical side of enforcement. Remember that deemed decree idea we talked about?
Right, that legal upgrade that makes a foreign award into a domestic order gives it the same power as a decree from an Indian court. Kind of levels the playing field.
Exactly. That was key to the Glencore decision. The court basically said, once a foreign award is enforceable, it's part of our system. We can execute it wherever the assets are.
So it's like saying, we're not going to let technicalities get in the way of justice.
That's it. Glencore took away a big obstacle for those trying to enforce awards, gave them more flexibility, more options. They weren't stuck filing in just one specific court. They could choose the court that was best for actually getting what they were owed.
It's like a treasure hunt. Follow the assets to find the best way to enforce the award.
I like that. It really captures the essence of Glencore, shifting the focus from procedural hurdles to practical solutions, making the whole enforcement process smoother.
So both Vodafone and Glencore, they seem to be sending a signal that India is shifting its approach, becoming more pro-enforcement, and that strengthens its reputation as a, what did you call it, an arbitration-friendly jurisdiction.
Absolutely. Those cases are like milestones, showing that India is moving towards a future where international arbitration is embraced.
It's like saying, hey world, India is open for business, we're reliable, and we'll make sure disputes are resolved fairly.
Exactly, but let's not forget about the public policy exception, that wild card that can change everything.
Yeah.
I'm really curious, how did the Balco case deal with that? It's such a complex and sometimes controversial issue.
Right. Balco, if I remember correctly, involved the privatization of that state-owned aluminum company. And the Indian government used that public policy argument, saying that enforcing the award would hurt their domestic aluminum industry and undermine those privatization policies.
That's right. It was a big fight, really testing the boundaries of that public policy exception. The courts had to grapple with a fundamental question: when is it okay to ignore a foreign award?
So what happened? Did the Delhi High Court agree with the government, or did they side with Sterlite? Did they uphold the award?
It wasn't a simple decision. The Delhi High Court, in a split decision, ended up upholding the Arbitral Award. But the reasons behind their decision are what's important for understanding how India approaches this whole public policy thing.
A split decision, so even the judges weren't totally on the same page.
Right. Most of the judges agreed that public policy is a valid reason to refuse enforcement, but they also stressed that it should be a last resort, used only in extreme cases, not just whenever it's convenient.
So not just because it's a headache for the government or unpopular politically?
Exactly. They said courts should be very careful about using this exception because, it could undermine the whole system of international arbitration, make people lose faith in India's commitment to upholding its agreements.
So it's like they're saying, we're not going to abuse this exception. It's a safeguard, not a loophole to get out of things we don't like.
Right. They emphasize that it's not about second-guessing the arbitrators or redoing the whole dispute. It's about making sure the award doesn't go against India's core legal principles or its basic values.
So in the Balco case, did they think the award crossed that line?
They didn't. They looked at the government's arguments, but ultimately decided that the concerns about the aluminum industry, they didn't rise to the level of a public policy violation. They pointed out that Sterlite had a fair chance to present its case in arbitration. There was no evidence of any wrongdoing, nothing that would justify overturning the award.
So it's like saying, we hear you, but your concerns aren't strong enough to ignore this whole process.
Exactly. They emphasized that respecting the finality of those arbitration decisions, that's crucial. You can't just go around overturning awards whenever they're inconvenient.
It sounds like a win for the integrity of the arbitration process, but I bet the dissenting judge had a different take on things. What were their concerns?
You're right. The dissenting judge, they felt that the potential fallout, the economic and social impact of enforcing the award, That was serious enough to justify using the public policy exception. I thought the privatization of Balco was a huge deal for India and that enforcing the award could really damage the domestic aluminum industry.
So is a clash between protecting economic interests and respecting these international agreements.
Exactly. And that dissenting opinion, it just shows how complicated this whole public policy exception can be. It's a balancing act, and different judges may see those competing interests differently.
Balco, even though it's a split decision, it shows how important it is to use the public policy exception carefully and thoughtfully. It's a safeguard, not a get-out-of-jail-free card.
I agree. And these three cases, Balco, Vodafone, and Glencore, they really show us how India's approach to all of this is changing. We see more clarity, more predictability, a real commitment to respecting international arbitration.
It's like India's finding its footing on the global stage, asserting its independence, but also embracing its role as a reliable player in the world of international business.
That's a great way to put it. But we're not done yet. In part 3, we're going to zoom out, look at the bigger picture, the future of all of this in India. What are the trends, the roadblocks, and what can India do to really become a global center for arbitration?
So join us for part 3. We will break out our crystal ball and see what the future holds for this exciting, rapidly evolving area of law. Welcome back to LexTalks. We're wrapping up our deep dive, into the world of enforcement of foreign awards, specifically those procedures and essentials under the New York Convention. Remember, in parts 1 and 2, we laid that groundwork, explored those big landmark cases like Vodafone, Glencore, Balco. We saw how India's approach is evolving, right?
Yeah, definitely a shift towards a more pro-enforcement stance. Courts are getting clearer on those key principles, upholding those international agreements, but now we got to look ahead.
Exactly. What's next? What's the future of all this, in India? Are we on the path to becoming a global arbitration hub, or are there going to be some bumps in the road?
It's a journey, right? Think of it like that. India's moving in the right direction, but there will be twists and turns. It's never a straight line.
Okay, so let's map out this legal roadmap. What are some of the good signs? Those things that tell us India's on the right track.
Well, one encouraging thing is that the government seems committed to making India more arbitration friendly. Remember those 2015 amendments to the Arbitration and Conciliation Act? Those were a big deal.
Yeah, those were all about streamlining the process, making it more efficient, cutting through the red tape.
Exactly. And setting up those specialized commercial courts, that was another smart move. Those courts are specifically for those high-value commercial disputes, including the ones from international arbitration. That means faster resolution, more expertise.
So it's like creating a fast track, specifically for those complex cases.
That's a good way to put it. Those reforms, they show the international community that India is serious about this whole arbitration thing. They're saying, we're ready, come and do business here.
It's like rolling out the red carpet, right? Right. We're open for business. We've got a solid system for resolving disputes fairly and efficiently.
Absolutely. And there's something else. More and more people, both in India and internationally, are seeing arbitration as the best way to resolve those disputes.
So it's not just about the laws, it's also about changing mindsets.
Right. More businesses are putting those arbitration clauses into their contracts. They're realizing it's more flexible, more confidential, and you get those experts involved. It just makes sense.
So they're saying, let's avoid the whole mess of going to court and go for something more tailored, more efficient.
That's it. And as that trend keeps growing, it's going to make India even stronger as a global arbitration hub. But of course, there are always challenges. There are always bumps in the road.
Okay, so what are those roadblocks? What are the legal potholes we need to be watching out for?
One persistent challenge is that public policy exception. It can be a bit of a double-edged sword, right? It protects India's core interests, but it's also broad and subjective, and that can create uncertainty.
Right, remember Balco. Even the judges had a tough time figuring out when that exception should apply. It was a close call.
Exactly. And that lack of clarity, well, it can make some foreign investors nervous about choosing India for arbitration. They want predictability. They don't want the rules changing in the middle of the game.
It's all about building trust.
Yeah.
Showing that the system is reliable and fair.
Right. So one area for improvement would be having some clear guidelines for applying that public policy exception. Courts need to give clear reasons for their judgments so everyone's on the same page, set a standard.
So it's like a legal compass, guiding everyone towards a shared understanding of what public policy really means in this context.
Exactly. And then there's another challenge. Even when an award is enforceable, sometimes there are delays in the actual execution. It's not always a quick victory, even when you win.
So you win the legal battle, but then there's all this other stuff to deal with.
Unfortunately, yes. Procedural stuff, bureaucratic hurdles, all sorts of appeals. It can really drag things out, make it expensive and frustrating for everyone involved.
It's like running a marathon, crossing the finish line, only to find out there's an obstacle course waiting for you.
Exactly. So streamlining that whole enforcement process, that's another area for improvement. Less bureaucracy, making sure courts have the resources they need to handle these cases quickly and efficiently.
It's about putting those words into action, showing that India really is arbitration friendly, not just in theory, but in reality.
Absolutely. And finally, India needs more good arbitrators, experienced, skilled people who can handle these complex international disputes. As arbitration becomes more popular, the demand is going to keep going up.
It's like assembling a dream team of legal experts ready to tackle those tough cases.
Exactly. And India needs to invest in training programs, mentoring, all that good stuff. So we have a strong pool of arbitrators who are respected, both in India and around the world.
So it's a multi-pronged approach, right? Improving the laws, streamlining the process, and building up the communities of experts.
Exactly. And if India can do all that, I think we have a real shot at becoming a global arbitration hub.
It's exciting to think about. And for you guys listening, all you aspiring lawyers out there, this is a growing field, tons of opportunities. Imagine shaping the future of international arbitration in India, helping to resolve those complex disputes. You could play a role in India's growth on the global stage.
It's challenging for sure, but also rewarding. You need legal expertise, of course, but also strategic thinking. You need to be culturally sensitive and passionate about finding creative solutions to those tricky problems.
So to all those future lawyers out there, embrace the challenges, stay curious, and be ready to jump into this fascinating area of law.
And that brings us to the end of our deep dive into the world of enforcement of foreign awards here in India.
We've explored the legal framework, those key conventions, those landmark cases, the challenges, and the exciting opportunities that are on the horizon.
Hopefully you found this journey insightful. Maybe it sparked your curiosity about this area of law which is constantly changing.
Remember law. It's not just about rules and regulations. It's about finding solutions, making sure things are fair, and shaping how we interact in this globalized world.
Keep those legal minds working. Don't forget to subscribe to LexTalks for more deep dives into the legal world.
Thanks for listening.